Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, for those of you who've been geeking out on this channel for a while, and for those of you who are new to the channel, listen, there is one of two ways that a state other than Washington is likely going to be covered by Washington Gun Law. The way we like to cover states is because they've done something so incredibly awesome to protect their citizens' otherwise inalienable rights that candidly we just feel the need to brag about how cool that state is. Now, that does happen, but unfortunately it does not happen with as much frequency as we would like. The more common way, however, that your state will be covered by Washington Gun Law, well, that's to do something so stupid, so crazy, so sinister, so evil, in stripping your citizens of their otherwise inalienable rights that we feel compelled to do a video to warn all the other states to ensure that the stupidity in your state does not cross state lines. Today, however, we're going to welcome a new state to the club, and it's a state that's actually kind of stuck in the middle. They have some very important decisions to make this summer. They're either going to go continue down the road that they've been going, which is one that it protects its citizens of their constitutional rights, or they're going to take a very sharp detour and suddenly become a rather rabid gun control state. So today, let's spend a few minutes and let's talk about Tennessee, a state teetering on the brink of gun control. Okay, so the topic we're talking about today is the state of Tennessee. Why are we talking about the state of Tennessee? Well, the legislative session in Tennessee just wrapped up, and there is strong criticism of the legislature's inability to pass any type of meaningful gun control legislation, whatever the hell that means, especially in response to the horrific shooting that took place a few weeks ago in Nashville. Now, while many on the gun-grabbing left would suggest that the gun itself went into that school and shot the place up all by itself, and we do not even need to focus on the shooter's manifesto, one would seem that we should probably understand the entire problem and have a thorough understanding of the entire problem before we begin to figure out what the solution is. But I digress. The problem is that there has put a tremendous amount of political pressure on Governor Bill Lee to do something. Okay, now let's take a step back here and talk about the state of Tennessee. Where does the state of Tennessee sit as it relates to protecting its individual citizens' liberties? Well, Giffords gives the state of Tennessee an F, which in my book means you're probably getting an A, worst case scenario, A-. Tennessee is a state that is constitutional carry. Tennessee is a state where a person, once they're age 18, can purchase any type of firearm, and there is no minimum age for possessing shotguns and rifles. Tennessee is a state that once you clear your background check, you are entitled to take possession of the firearm. There are no statutory waiting periods. So the state of Tennessee, for all intents and purposes, is a state that prides itself on protecting the individual liberties of its citizens. But now, Governor Bill Lee, succumbing to political pressure, well, not only does he want the Tennessee legislature to implement a red flag law, which we'll talk about in a moment, he's actually ordering the Tennessee state legislature back into a special session this August 21st. That's right, in the heat of the summer. They all get to go back to the state capitol and figure out new and creative ways to strip you of your Second Amendment rights. Now, for those of you in Tennessee and those of you who live in one of the many jurisdictions that does not have red flag laws, currently, there are 19 states plus the District of Columbia that have red flag laws. My state, Washington State, is one of them. I'm going to make a very controversial statement, and before you guys start blowing me up in the comment section, hear me out. I believe that the purpose of red flag laws, the heart of the people who are behind it, are in the right place. Okay, I have represented many people on red flag hearings. I have prevailed on almost all of them. I have lost a few. And there have been some instances where I have felt that that individual likely should have not had access to firearms. Now, that's based upon individualized circumstances with that particular individual. So when I say that red flag laws can save lives, that I believe is a true statement. Now, again, before you all start blowing me up, hear me out. Here's the other thing I would say about red flag laws that is also equally true. The implementation of red flag laws absolutely, completely eviscerates, demolishes, and disregards the constitutional rights of every single respondent. Let me say that again, okay? No matter how noble the cause is, the manner in which red flag laws are implemented is absolutely unconstitutional on multiple levels. Now, Governor Lee has put forth a 13-page proposal of what he would like to see the Tennessee red flag laws look like. I had an opportunity to review it. We're not going to get too far into those woods today, but in essence, this would expand Tennessee's current domestic violence protection order program. Only law enforcement would be allowed to petition. The orders would last for a period of 6 months, and the evidentiary standard by which an order must be proven is clear and convincing, which is a higher burden of proof than what most jurisdictions use, which is preponderance of evidence, okay? Now, while all of that may seem very innocuous, this is what I want you to understand about red flag laws, okay? Is that when a person petitions to have a red flag law entered, or red flag order, extreme risk protection order is what we call them here in Washington State. The initial petition and temporary order is done ex parte. What does that mean? It's a fancy word for saying we only heard from one side. So if law enforcement wants to go petition against a Tennessee resident, they would get a bite at the apple without that resident even having any chance to respond. And if the court believes there's sufficient evidence to grant the order, they will issue an emergency temporary order. That order strips that individual of their Second Amendment rights and requires law enforcement to go out and seize all the guns. Now think about this. That is a seizure which is occurring without the other individual even having a chance to be heard yet. Is there an opportunity for the individual to later be heard? Yes, there is, but that may occur weeks or months later, and in the meantime, that individual has been disarmed, and they've been disarmed based merely upon allegations, and many times those allegations don't rise to the level of criminal conduct. What do I mean when I say the constitutional rights are completely eviscerated? Well, in two regards. Number one, you're stripping a person of their otherwise inalienable Second Amendment right of self-preservation, and you're doing so without them being convicted of a crime or found mentally incompetent or any of the other more traditional reasons by which we can strip an individual of their Second Amendment rights. So there is a clear violation of that constitutional amendment. But here's the other thing. When you are going to take a person's life, liberty, or property, they are entitled to procedural due process. Okay, due process under the law in a procedural nature basically means you are entitled to notice. You are notified of what the allegations are against you, and you are entitled to a meaningful opportunity to be heard where you can put on a defense and confront your accusers. The problem for red flag laws, of course, is that if it occurs at all, occurs months or weeks after the individual's already been deprived of the rights, and in many cases, live testimony is not permitted. It's all done on declarations and affidavits, and I can assure you from being a trial lawyer for the last 25 years that trying to cross-examine a piece of paper can be quite difficult. And the other thing Governor Lee and the Tennessee legislature needs to be aware of is that there is plenty of data now of states that do have red flag laws and states which don't. And there is absolutely zero decipherable difference in the amount of violent homicides and other gun crimes that occur in each of those respective jurisdictions. So, Tennessee, you have a long, rich tradition of standing up for and protecting the individual rights of your citizens. But now, due to horrific events and political pressures, you are being asked to abandon that position and to implement perhaps one of the most unconstitutional forms of gun control measures known to the United States, which is red flag laws. You have some very important decisions coming up, and these decisions will affect the future of the individual liberties of every citizen of Tennessee. Listen, you may have more questions about what's going on in Tennessee or anything else related to what's left of our Second Amendment rights. If you do, you should know how to contact Washington Gun Law by now, but if you don't, that's okay, because that information is right there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.